Good morning, all. We're here today for a hearing in the matter CFI 47, 2016, before His Excellency Justice Shamlan of Sawalehi. The respondent is represented by Alan Overy, lead counsel is Yasin Francis. The applicant is the litigant in person, represented by Fadi Ashami.
All right. My understanding that the defendant being the applicant in this procedure representing by a non-practitioner lawyer, is that right?
Yes.
Yeah, indeed. So your name in the trade license already, or can I have a copy of the trade license?
Yeah.
Yeah? Because I don't have it here in my file. Okay. Thank you. So this is why maybe can you stand? Just I want to talk to you. In normal procedure, the applicant submit like a bundle to the court. So this is the responsibility of the applicant. But I understand you don't have a legal background. Maybe this is why nothing happened.
Actually, sir, I need a little bit time because I'm in this company since 2 months only.
Yes.
I'm trying now to restructure some problems for this company.
Right.
So if you can give me a little bit time to arrange, to try to make restructuring with other party at the first and the second things, to appoint a lawyer to be with me the next time, if we need that.
So are you coming today just to let me that you need a time to prepare yourself, the company, the applicant, or you want to go through the application?
Yes, I'm trying to make restructuring with other party.
No, this is very late, I'm afraid. I mean, the purpose for today is to hear from the applicant, to hear from you, and for the respondent, being the claimant in this case, to address his point. But not the purpose today is to adjourn this hearing. You should do this earlier. You should send an email by yesterday or the day before, or last week, to ask for any adjournment.
Sorry for that, because I don't have any background.
You don't have any background, but you should ask the court by email to adjourn this hearing, but not coming the same day and ask the court to do so.
I'm sorry.
So this is not accepted at all. Now, you want to continue and address me with any point you want to make in terms of contest the jurisdiction of the IC court, or you don't, or you prefer not to say anything at this stage? Then we'll turn to the respondent and hear from them.
Yes, sir. That's better.
So you don't to say anything to the court at this stage?
Yeah.
All right. Thank you very much. So in this case, we'll turn to the respondent and we'll hear from them their argument about the application.
Thank you, Your Honour.
Yes.
As you've covered, this is an application by the defendant to contest the jurisdiction of the DIFC courts. It's opposed by the claimant. I'm here to represent the claimant, Natixis S.A, the bank in the underlying claim against the defendant, who is the borrower. Now, the substantive claim relates to a facility agreement by which the claimant provided the defendant with a loan facility of up to $30 million. And the claimant's claim relates to the defendant's failure to pay certain amounts due under that facility agreement. Now, we say, on behalf of the claimant, that it is very clear that the DIFC courts do have jurisdiction to hear and determine the claimant's claims under the facility agreement by reference to the judicial authority law. We say this is very clear on a number of bases. If I can just take you to the judicial authority law, which appears at tab 16 of the bundle that the claimant prepared and submitted to the court last week. I have provided a hard copy this morning to the defendant, so he also has a copy to refer to as we go through today. So tab 16, and if we look at Article 5A1A, of the Judicial Authority Law, which will be well familiar to Your Honour, which provides that the DIFC Courts has exclusive jurisdiction to hear and determine civil or commercial claims and actions to which the DIFC or any DIFC body, DIFC establishment or licensed DIFC establishment is a party. Now this gives rise to the present question as a starting question for defence of this application. Is the claimant a DIFC establishment and or a licensed DIFC establishment? Now the Judicial Authority Law defines both of those terms at the top of the Judicial Authority Law. So DIFC establishments, any entity or enterprise established, licensed, registered or authorised to carry on business or conduct any activity within the DIFC pursuant to DIFC laws, including licensed DIFC establishments, and then just below that, licensed DIFC establishments, any entity or enterprise licensed, registered or authorised by the Dubai Financial Services Authority to provide financial services or conduct any other activities in accordance with the DIFC laws. And we say that it's very clear that the claimant in these proceedings satisfies both of those limbs. It is both a DIFC establishment and licensed DIFC establishment. If I can take you to the claimant's DIFC commercial licence, just to make good that point. If we can turn to tab 6, and it appears towards the back of the documents in tab 6. So if you count in 4 pages from the back, it should be headed C006 in the top right corner. Right. Do you have that? Sure. This shows that the claimant has a DIFC commercial licence. Its legal status is a foreign recognised company, and it has a business address and presence in the DIFC. So we say that this makes the claimant clearly a DIFC establishment. If you turn over the page, you will see that there's an entry from the DFSA register, which shows that the claimant is an authorised firm. And if you turn over the page, you'll see that the licence was first awarded to the claimant on 28th November 2006. So it's had a licence to provide financial services in the DIFC since 28 November 2006. So we say that makes good the second point, which is it is clearly a licensed DIFC establishment. If we go to the beginning of tab 6, we'll see the facility agreement. So it's the second page of tab 6 is the beginning of the facility agreement. This is dated 22nd December 2015. It's addressed to the defendant, Fast Telecom General Trading LLC. And you see at the bottom, in the footer, it refers to the Dubai branch regulated by the DFSA and gives the claimant's address within the DIFC.
May I just notice something here? The date of this agreement is 22nd, 2015.
Yes, right.
And the company, you say, registered since 2016.
Sorry, Your Honour, could you
The registration of the company since when is it?
28 November 2006.
Sorry, yes.
So well before
So, yes.
the date of this agreement.
Right. Okay, sorry, continue.
So we say that we get home on the very first limb of Article 5A 1A, and that is, we say, abundantly clear. Now, if we can go back to the Judicial Authority Law, at tab 16, we say we also satisfy the limb at 5A 1B, which provides that the DIFC courts shall have jurisdiction in civil or commercial claims and actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalised or performed within the DIFC. I don't need to read the rest of that, because for the facts of this case, the key question is, was the contract partly concluded or finalised within the DIFC? And we say the answer to this question is, again, very clearly yes. If I can take you back to the facility agreement in tab 6, and if we turn to page 21.
Tab 6, 21.
So tab 6 and internal page reference, page 21 or 28.
Yes.
This is the signature page of the facility agreement, and it shows clearly that this was signed in the DIFC. You see that there's a stamp of Natixis DIFC-Dubai, with the signatories being Mr. Omar Benikran and Miss Faye T, both of Natixis. Now, I will take you to the witness statement of Mr. Benikrani, which is at tab 11, which just provides some further factual evidence on the circumstances of the signature of this facility agreement. So, tab 11. Mr. Omar Benikrani is the claimant's Executive Director of Global Transaction Banking for the claimant's branch in the DIFC. And he's one of the signatories to the facility agreement on behalf of the claimant. Now, paragraph 13 provides the evidence in relation to the circumstances of the signature of the facility agreement. And you see in paragraph 13, it says, on or around 28 December 2015, the DIFC branch received the signed execution copies of the facility agreement from Fast Telecom. Ms. T and I subsequently signed and stamped the execution copies on behalf of Natixis on or around 4 January 2016. We signed and stamped the execution copies at the DIFC branch's offices within the DIFC. So we say that that is clear factual evidence which is uncontested by the defendant and the applicant in these proceedings, which shows that this contract was finalised and concluded within the DIFC. So we say we very clearly satisfy the limit at Article 5A(1)(b) of the Judicial Authority Law.
Just for clarity, this is the applicant witness statement, or this is the...
This is the claimant's witness statement.
All right.
So Mr. Omar Benikrani is, as I said at the beginning of this submission, he's Executive Director of Global Transaction Banking for the claimant. So the claimant's branch in the DIFC,
right,
which is the respondent to this application.
Okay.
Now, if we go back to the Judicial Authority Law at tab 16, we say we also satisfy the limb at Article 5A(1)(c), which concerns giving the DIFC courts jurisdiction in civil or commercial claims and actions arising out of or relating to any incident or transaction which has been wholly or partly performed within the DIFC and is related to DIFC activities. And this gives rise to the question, was the transaction partly performed within the DIFC? And we say the answer to that question is yes. Going back to Mr. Benikrani's witness statement at tab 11, at paragraph 14, there is evidence of the cash pledge that was provided by the defendant under the terms of the facility agreement. And those are clauses 6F and 9 of the facility agreement. And Mr. Benikrani's evidence is that the pledge agreement was sent to the defendant from the claimant in the DIFC. It was signed by the defendant and then returned to the claimant, again in the DIFC. And the claimant signed the pledge agreement in the DIFC. And this is all set out in paragraph 14 of Mr. Benikrani's witness statement. Now, the threshold that we need to satisfy in respect of this limb of the Judicial Authority Law, we say, is relatively low. The very fact that some part of the transaction that's contemplated in the facility agreement is performed within the DIFC, we say is enough to satisfy this limb of the Judicial Authority Law. So we say we get home on three separate limbs of the Judicial Authority Law to grant the DIFC court's jurisdiction to hear the claimant's substantive claims. So then the only remaining question is the jurisdiction of DIFC courts somehow excluded by some other agreement between the parties? So, and this is also contemplated in Article 582 of the Judicial Authority Law, which I will just read to save you from having to turn to it. The Court of First Instance may hear and determine any civil or commercial claims or actions where the parties agree in writing to file such claim or action with it, whether before or after the dispute arises, provided that such agreement is made pursuant to a specific, clear and express provisions. So the question here is, have the parties agreed in writing, in specific, clear and express provisions, that the DIFC court may hear and determine claims under the facility agreement? Now the answer to this question is yes. The jurisdiction clause in the facility agreement does not mention the DIFC courts, but we say that doesn't mean that the clause fails to cover the jurisdiction of DIFC courts. We say that clause, properly interpreted under English law, which is the governing law of the facility agreement, and DIFC law, in accordance with DIFC law precedent, that provision we say is sufficient to grant the DIFC court's jurisdiction, provided we also satisfy another limb of the judicial authority law. If I can just take you to the jurisdiction clause in the facility agreement. So if we turn back to tab 6, and this will be on page 20.
Okay.
And this is, you see the governing law provision at 28.1, so English law is the governing law. The jurisdiction clause is at 28.2. Now, subparagraph A of the jurisdiction clause grants jurisdiction to the courts of England. What we rely upon is subclause B, which provides this clause is for the benefit of the bank only. As a result, the bank shall not be prevented from taking proceedings relating to a dispute in any other courts. Now, this provision is very similar to the jurisdiction provisions that were considered by the DIFC Court of Appeal in the case of Investment Group Private Limited versus Standard Chartered Bank. If I can take you to that case, which appears at tab 21 of your bundle. And if I can ask you to turn to paragraph 148.
Yes.
And you see that this refers to Standard Chartered Bank's general terms and conditions, clause 11, and then this says SCB and IGPL agreed to submit to the jurisdiction of the courts of the UAE, and that SCB may, at its option, elect to commence proceedings in the courts of other jurisdictions, and IGPL agreed in such case to submit to the jurisdiction of such courts. Now, the court's consideration and discussion of that term and conclusion is contained in paragraph 152 below, and it picks up in the first sentence after the comma, where it says, by virtue of clause 11 of the SCB general terms and conditions, SCB is nonetheless entitled to commence proceedings in the courts of other jurisdictions, including the DIFC courts, for any claim arising out of or in connection with the 2009 agreement. And the DIFC courts would have jurisdiction under Article 5A1A of the Judicial Authority Law, on the grounds of SCB's status as a DIFC establishment. And we say that's pretty much identical to the position we're in. But if you also look at paragraph 149 just above, we've got a jurisdiction clause which is even more similar to the clause that we have in the facility agreement. So here at paragraph 149, it refers to a clause in a 2010 agreement, and it's subparagraph 3 there. By clause 36.2a, the parties agree that the courts of England shall have jurisdiction to settle any disputes or proceedings which may arise in connection with any finance document, and that clause 36.2a is for the benefit of the finance party only, and shall not limit the right of any finance party to bring proceedings against the borrower in connection with any finance document in any other court of competent jurisdiction, or concurrently in more than one jurisdiction. I say that wording is very, very similar to the clause we have in our facility agreement. And the court's discussion and conclusion on that clause is contained in paragraph 153 below, and it's the same. The conclusion of the court in this case is that the wording does not exclude the jurisdiction of the DIFC courts. So provided that another jurisdictional gateway of the DIFC courts is satisfied, this wording is sufficient to amount to an agreement that the DIFC court may hear and determine the relevant claims. Now we say this shows very clearly that we have multiple bases on which to grant the DIFC court's jurisdiction in this matter. Now, Your Honour, I don't know if it would be appropriate to look now at the defendant's submissions, or if you're prepared, if you've read the defendant's submissions already and you're prepared, you don't need any further assistance on that. But in case it's of assistance to you, I'm happy to go through each of the defendant's main arguments and just guide you through what our responses are to each of those categories of arguments. That would be helpful.
Yeah, that would be. Go ahead.
Okay, excellent. If we can just turn to tab 8, we have a copy of the defendant's written submissions in support of its application. And if we can turn to paragraph 12 of those submissions, this contains the first of the defendant's arguments in support of its application. And in summary, the defendant argues that the parties intended to amend the jurisdiction clause in the facility agreement by entering into the pledge agreement. The defendant says that the jurisdiction clause in the pledge agreement replaces the jurisdiction clause in the facility agreement. And the defendant argues this on the basis that the facility agreement is a document that is delivered pursuant to the pledge agreement. Now we say this is just factually and legally wrong, and there's no merit in that argument. The facility agreement predated the pledge agreement. There is no reference in the pledge agreement to any term amending any term of the prior facility agreement, and there is, we say, no basis to interpret any provision of the pledge agreement as amending the terms of the facility agreement. Not least, there's just no way it amends the governing law and the jurisdiction provision in the facility agreement. So that's our response on that, their leading argument. Now, at paragraph 16 of the defendant's submissions, the defendant argues that the claimant's DIFC branch is not a party to the facility agreement and therefore has no capacity to bring the claim in the DIFC courts. Now, the defendant appears to have misunderstood or to have not considered Article 5A 1A of the Judicial Authority Law, which provides very clearly that the claimant is a DIFC establishment and a licensed DIFC establishment. There's also a well-known and well-reported DIFC case law authority which confirms that the DIFC courts do have jurisdiction over a DIFC branch of a foreign bank. And the most well-known of the DIFC court cases on this is the case of Corinth Pipeworks S.A. versus Barclays Bank PLC. And if I can take you to the judgment in that case, which appears at tab 19.
Right.
And if we turn to paragraph 63, and this is in the judgment of the Chief Justice, this passage of the judgment confirms that there is no separation of entity between an unincorporated branch of a foreign bank and the foreign bank itself. And then if we turn over the page to paragraph 66, again, the Chief Justice judgment here is once it is established that an unincorporated DIFC branch of a foreign bank cannot be regarded as an independent entity for the purposes of qualifying as a centre establishment, it follows that this term can only be interpreted to mean the respondent and its various branches wherever located. Accordingly, the DIFC courts do have jurisdiction over the conduct of the respondent's Dubai branch, as it would have over any other branch of the respondent wherever located. Now, any ambiguity has been cleared up by this judgment and by the subsequent amendment of the judicial authority law, which made clear what the definition of DIFC court establishment and licensed DIFC court establishment was intended to mean. And we say, on either view, this covers the claimant in this action. If we go back to the defendant's submissions at tab 8, and look at paragraphs 27 to 29.
Okay.
Now, in these passages, the defendant argues that the claimant is prohibited from forum shopping, where it aims at artificially escaping from naturally applicable laws. Now, this argument appears to depend upon the defendant succeeding in its argument that the pledge agreement amended the governing law and jurisdiction clause in the facility agreement, so as to replace English law as the governing law with French law, and or to grant the Commercial Court of Paris with jurisdiction. And we say this is just factually and legally wrong. There's no merit in that argument, it just doesn't get past that assumption. There appears to be some overlap with the defendant's next arguments on good faith and public policy, so I'll move on to those and address those separately. But we say this argument on forum shopping is just hopeless and bound to fail. Now, paragraphs 30 and 31 on the same page contain the defendant's arguments on good faith. Now, the defendant argues that the claimant cannot proceed to enforce the pledge agreement in the French courts and enforce the facility agreement in the DIFC courts. Now, we say these agreements are separate agreements with different governing laws and different jurisdiction clauses. We say there's simply no factual or legal basis for the defendant's argument on this point. Over the page, paragraphs 32 to 34, the defendant has raised an argument based on the UAE public policy, saying that this prevents the claimant from exercising the unilateral right that was granted in the facility agreement that permits the claimant to bring its claim in the DIFC courts. Now, we've already gone to the judgment in Investment Group Private Limited versus Standard Chartered Bank, which has a provision, a jurisdiction clause, which is almost identical to the clause that we have in the facility agreement. And we say that DIFC court case law shows very clearly that jurisdiction provisions like our clause are valid and enforceable in the DIFC courts. So we say that DIFC case law is simply contrary to the defendant's argument on this point. So in conclusion, we say none of the defendant's arguments in support of its application have any factual or legal basis or any merit, and on that basis, we as the claimant ask you submit that the court should dismiss the defendant's application and confirm that the DIFC courts do have jurisdiction to hear the substantive claims in this action. Your Honour, that concludes my submissions on the application. We obviously have a cost application as well, if you make a decision in the course of this hearing, but unless I can assist you any further, those are my submissions.
Thank you. The only point I would like to hear from you, maybe more details about that articles and the provision in the pledge agreement in terms of the commercial court of French should have an exclusive jurisdiction. Whether or not you will interpret that as opt-out clause from the DIFC original jurisdiction, how you can, what's your position on that?
Your Honour, the first point is this is a completely separate agreement. So this does not form, this agreement, the pledge agreement does not form the basis of the claimant's claims before the DIFC court. So that's the first point. If the claimant was pursuing an action in relation to the pledge agreement in the DIFC court, then I think we would get into this debate, and there may well be arguments as to whether or not this jurisdiction clause has the effect of ousting the DIFC court's jurisdiction. We say even on that basis, it wouldn't oust the jurisdiction of the DIFC courts, because we are still a DIFC establishment and a licensed DIFC establishment. So then I think you just get into arguments about what would be the most convenient forum if we were pursuing a claim on the basis of the pleasure group. As I said, this is not relevant to the claimant's substantive claims.
Yeah, so my understanding, just correct me if I'm wrong, the claimant makes his claim based on the facility letter, not on the pledge agreement. Is that right?
Yes, correct. Right.
The second clarification, I just noticed, there has been some change in the claimant trade name or the licensing name. I've seen the DIFC, the DFSA letter mentioned that somewhere.
Okay.
On that letter, when you mentioned 2016.
2006. So if I just have one moment.
Yeah. If you can take me again to the same.
Okay. Yeah, if we can go back to the DIFC commercial license.
Yeah, that's what.
Yes. So this is the back of tab 6. You'll see that it had a former name. So current name is Natixis. It's the same entity, but the DIFC commercial license just records that it was formerly known as Natixis Banks Populares.
It's in back tab 6, is that
Yeah,
right?
the back of tab 6. If you count in 4 pages from the back of tab 6, you should have it.
It's
And it's in the first couple of entries, a company name and trade name. It just records what the former name was, but it's the same entity. And
yes, formerly known as Natix Bank or something, popularized. Now that was issued in 2016. The new commercial license was issued in 2016. Acknowledging that the name has been changed. Is that right?
yes, Your Honour. I'm not entirely sure when the name was changed.
That's fine, but
I believe that.
so I'm assuming in 2015, when they signed the letter agreement, they signed it under the previous name.
No, Your Honour. I believe, and I will be corrected very quickly if I'm wrong, that by the time of the facility agreement, the name was actually Natixis. I mean, that is the name that appears on the facility offer letter, so the facility agreement. And I think as a defined term, the bank is also referred to. If I can just turn. Yes, in the defined term at the back, or in Schedule 1, so this is page 22 of 28 of the facility agreement, it refers to the name that it currently has in these proceedings, so Natixis S.A. I'm informed that the name change occurred in 2007.
Now, is there any difference between Natix and Natix S.A.?
No, it's the same.
And that does not appear in this commercial license, the Natix S.A. And the agreement was signed by Natix S.A. or Natix?
Well, it was signed by Natixis S.A., but I'm not sure if the S.A. always made its way into the references to Natixis even within that agreement. I will just go to the signature page. So yeah, if you look at the signature page, you just refer on, sorry, this is page 21 of 28, the stamps, I mean, it says yours faithfully for Natixis S.A., but then the stamp just says Natixis, DIFC Dubai, and Natixis Dubai.
Now, the commercial license say Natix without S.A., then the regulatory, the DFSA say what? The DFSA license.
Yeah, the DFSA license just refers to Natixis. It doesn't have the SA on the end of it. But we say this is the same entity. And,
main reason behind choosing the French court for the security agreement was what exactly?
Well, I hesitate because we don't have evidence from Mr. Benicani, but I would assume it's because the security is actually located in France, so the account located in France, so it would be natural for that to be governed by French law and be subject to the jurisdiction of French courts. But I don't have evidence on that. Yes. Actually, I'm reminded by my colleague, Mr. Kuzikanani, at paragraph 15 of Mr. Benicani's witness statement, we do have evidence of Mr. Benicani's understanding of the reasons. So if I can take you to tab 11, and if we turn to paragraph 15 of the witness statement.
Yes.
Where it's the last sentence in paragraph 15. Further, I understand that the reason the pledge agreement provided for French law as the governing law and the jurisdiction of the French courts was again for enforcement purposes, given the pledged cash account was located in France. So my guess was correct based on the understanding of Mr. Benicani.
But my understanding, the cash, the loan was withdrawn or given from the DIFC branch or from French, the main company.
Well, the DIFC branch is there's no separate personality. There's no separate legal personality. So the contract is obviously entered into.
In terms of transaction, that went from the French bank, right? Not the DIFC itself. This is why the clause was French court. If my understanding, the DIFC entity, they maybe get involved in the negotiation and the drafting the contract. The facility letter, but the actual money came from the Paris headquarters bank. This is why they made the security, the lodge agreement is subject to the French court.
Well, the pledge agreement operates in a very different way to the facility agreement. It may be helpful if I take you to the terms of the facility agreement which contemplate the pledge agreement. How it operates in a nutshell is, as security, the defendant was required to open a bank account and, based on the witness evidence, open a bank account in France, pay money into that account, which was then held as security for the loan. So completely separate from the arrangements in terms of where the money came from under the loan. So the pledge agreement and the facility agreement are separate agreements, to be clear. But your assumption as to where $30 million is likely to come from in terms of financing the loan, it may well have come originally from the bank in France.
But we don't have any evidence.
But we don't have any evidence, and this is not a point that's been taken by the defendant in the application.
All right. Will you want to address the cost right now, if you like?
Yes, Your Honour, do you have a copy of our statement of costs? I can hand one up. Okay.
I don't think so. No.
Okay, well, let me hand a copy out.
Now, this is the cost for this hearing or for the previous?
Just for this hearing. So this is just the cost of dealing with the defendant's application to contest jurisdiction. And we would ask the court to make an immediate assessment of our costs if the court is minded to dismiss the defendant's application. And that immediate assessment would be made pursuant to Rule 38.30. Now, in support of our application for immediate assessment, we would remind the court that, or we would inform the court that we, as the claimant, propose that this application should be dealt with on the papers, and we proposed this by an email dated 23rd January 2017. And the defendant indicated that it would respond to that proposal, but didn't in the end. If you accept our submissions that this application is hopeless and bound to fail on multiple grounds, we say that we should be granted our costs of dealing with this application, and that should be borne in mind in terms of any discount that's applied to those costs. Now, the defendant's lawyers came off the record on 2nd of March 2017, and the defendant didn't withdraw its application or ask for any further adjournment. There were several adjournments of this application as well, by agreement between the parties. Now, since the defendant lost its lawyers, since they came off the record, the claimant has gone to considerable trouble and expense to respond to the application and to prepare for this hearing, and indeed to try to help the defendant to prepare for the hearing by reminding the defendant of its obligation to prepare hearing bundles and submit skeleton arguments and to appoint a lawyer for the purposes of these proceedings. So we say, Your Honour, that all of that should be borne in mind in terms of determining what level of costs should be granted to the claimant should the court dismiss the defendant's application. You have our statement of costs. I'm happy to go through any of the detail of that statement of costs if that would be of assistance to the court.
That was prepared in accordance with the Registrar Direction 2 of 2015. You're familiar with that? The Registrar Direction regarding indication of our legally charged, where he set out some guidance. It was just a guidance.
It's using exactly the form provided by the DIFC court. Are you talking about
the rates?
The rates. I can assist you on the rates. There is some slight difference between rates. So Practice Direction number 1 of 2017. Now, Mr. Kuzakanani's rate is higher than the average hourly rate. So in the Practice Direction we have it in dirhams, so 1762 dirhams for Mr. Kuzakanani's category, which works out at $480 per hour. Now, the actual rate is $525 per hour. Now, the other rates for myself and the partner on the file are lower than the average hourly rates in the Practice Direction. So, for myself, I'm in the 10 plus years bracket, so for US dollars that's 667. My actual rate is 660. The partner, US dollars, 768. The actual rate actually is it's $2 higher, so 770. So I was incorrect in my previous submission on the other two rates are below. It's about the same, 768 by comparison to 770 for the partner rate.
Okay.
If you were going to make the adjustment to reduce Mr. Kuzakanani's rate, and to reduce the $2 per hour of the partner rate, that would lead to a reduction which takes our cost claim down to 40,183.20.
All right, thank you very much. I will assist that in my order.
Thank you, Your Honour.
I'm done with that, and unless you want to address anything.
Your Honour, no,
Thank you very much.
That's all my submissions.
Mr. Fadi, you would like to brief comment on what you've heard today, or you will hold the same position, right? Thank you very much for that. We'll try to issue my order as soon as I can, because I don't think this is a complicated application. It's very straightforward. So thank you very much for both of you, and have a good day.
All rise.